All right, young champions of democracy, here we go. This is your flip classroom on the Supreme Court cases. In this video, I'm going to focus on some of the cases involving the First Amendment. Now, you are going to be required to know each and every one of the 15 cases required by the College Board. They include Shinnick v. U.S., Tinker v. Des Moines, New York Times v. U.S., Engel versus Vitale, Wisconsin v. Yoder, McDonald v. Chicago, Gideon v. Wainwright, and Roe v. Wade. Now, in addition to these cases, there are a couple others, including Marbury, McCullough, U.S. v. Lopez, and the Citizens United case. And we'll be dealing with those. Some of those we've already dealt with. But you're going to need to know these pretty extensively. For our flip classroom videos that you're going to watch today, I'm going to be providing you with supplemental Supreme Court cases. These are cases that may, in one way or another, relate to these other cases. So when you are briefing, when you are outlining, and when we are discussing, it's important that you're going to be able to not just know the case before you, but also how other rulings in the cases that we discuss in these flipped classrooms, how they may be used to be applied. So just to recap, what is the difference between a civil right and a civil liberty? Well, civil right protects groups from discrimination, while civil liberties protect individuals from government actions. Think civil rights, think the Civil War amendments, the 13th, 14th, and 15th Amendments. We said chief among those, the 14th Amendment being probably one of the most important amendments to the Constitution. The Equal Protection Clause in the case of Brown v. Board of Education and the Civil Rights Act of 1964. One of them, Brown, is a Supreme Court case, Civil Rights Act being a mandate of that case. We have women's rights, Title IX, and what's called strict scrutiny of a suspect class. These are all terms and items that you're going to need to know. We have gay rights and the struggle for equality. We have DOMA, the Defense of Marriage Act, which was struck down by the Obergefell case, Obergefell v. Hodges. Civil liberties, well, anything we deal with, freedom of speech, freedom of the press, freedom of religion, due process, searches and seizures, privacy, abortion, and the rights of the accused. And an important court that you'll need to know for the expansion of civil liberties is the Warren Court. All right, so what is due process? So we discussed this in class. Okay, the first case is Barron v. Baltimore, 1833, and this is where wharf owner John Barron had some property that was taken, and what happened was the city of Baltimore diverted water from his wharf. As a result, he sued and said that the city of Baltimore had violated the takings clause of the Constitution. Unfortunately, Chief Justice John Marshall, who, as we know, expanded federal power, declined to hear the case. He said that the Bill of Rights restrains the federal government and not the state government. Now remember, in 1833, this is about 28 years prior to the start of the Civil War, there is no 14th Amendment. There is no incorporation clause. Right now, there's only the first 10 amendments. So, unfortunately, Barron loses his case. That changes with the 14th Amendment. And again, possibly the most important amendment of the Constitution. It says that all persons born or naturalized in the U.S. are citizens, and that no state can deprive any person of life, liberty, or property without due process of the law. This now incorporates the Bill of Rights to the states, but it's not automatic. It has to be challenged in court. And one of the first cases to deal with incorporating the Bill of Rights to the states is Gitlow v. New York in 1925. So this was the case where Benjamin Gitlow was arrested for violating the city of the city of New York's anarchy law. Gitlow was arrested for writing and publishing and distributing thousands of copies of pamphlets called the Left Wing Manifesto, which called for strikes and class actions in any form. So in his arrest, he appealed to the ACLU, the Americans with Civil Liberties Union. They appealed the case, and they argued that the First Amendment protects this speech. Interestingly enough, the Supreme Court did uphold Gitlow's conviction, meaning they didn't release him. But In the majority opinion, the court said that for the present purposes, we may and do assume that the freedom of speech and freedom of the press are among fundamental personal rights and liberties protected by the Due Process Clause of the 14th Amendment from impairment by the states. So Gitlow goes to jail, but the Supreme Court puts the states on notice, saying you can't do this. Individuals are now guaranteed their rights and freedoms of speech. So then, and a very important concept, the next major free speech case is Neer v. Minnesota. So if Gitlow was a shot across the bow to the states, Neer v. Minnesota was the application of that first shot. So Minnesota attempted to bring an outrageous newspaper under the control of Neer with what's known as the Minnesota Gag Law. Okay, and this basically said it's a public nuisance law, and the statute permitted a judge to stop obscene, malicious, and scandalous and defamatory material. And J.M. Neer, who printed anti-Catholic, anti-Semitic, anti-Black, anti-labor stories, was prosecuted under it. And again, the ACLU came to his rescue. So in Neer v. Minnesota, the court declared that the Minnesota statute raises questions of, quote, grave importance, and it is no longer open to doubt that the liberty of the press is within the liberty safeguarded by the Due Process Clause of the 14th Amendment. So here you have it. Again, and we discussed this in class, in Neer, Minnesota, the Supreme Court says, yeah, individuals have this right of free press as protected by the First Amendment. So that brings up an important concept in Neer, Minnesota, which is the idea of prior restraint. So just to recap again, prior restraint is that the government of the United States cannot prevent material from being published, and that censorship is unconstitutional. The only exception is if national security or wartime, or if it's time of war. The government can call for what's called an injunction after something is published, but it cannot restrain material from being published. That is illegal, and that's the big takeaway from the Neer case. Again, free speech is probably one of the most basic freedoms that the Supreme Court throughout the years has fought to consistently protect and enlarge. Okay, so national security and public danger. So this is a case, again, that we are going to look at pretty extensively in class, Schneck v. U.S., and this was in 1919. So a little backstory for you. In 1917, the Congress and Woodrow Wilson signed the Sedition and Espionage Act, which prevented public criticism of the government and said that that was punishable by, it was treasonous, if you will. So you have Charles Schneck, who was this, I think he was a member of the Socialist Party. I think he was the secretary of the Socialist Party. Printed, 15,000 anti-draft leaflets in the Philadelphia area. And he was arrested, and he appealed the verdict. And the court drew a distinct difference between speech that communicated honest opinion and speech that incited unlawful action. And that's, the Supreme Court will hear these distinct differences. So in a unanimous opinion delivered after the war's end, the court upheld the government's right to define prohibited speech and convict citizens for using it. The question in every case was whether the words are fighting words. And this is where we get the, quote, clear and present danger test. And this is becoming the balancing act between competing demands between free expression and the need to protect a free society. So, example, and you've heard this 1,000 times, you can't yell fire in a movie theater because now you're endangering the welfare and the lives of other individuals. And here's Schneck's pamphlet, which we're going to read. Okay, obscenity. So how does the Bill of Rights protect free speech? So we'll take a look at the case of Roth v. U.S. in 1957. All right, so from the 1950s to the 1970s, there were a lot of cases, not a lot, but the Supreme Court dealt with what is obscenity. So in this case, in 1957, Samuel Roth was a publisher of, shall we say, questionable books, and he was prosecuted under what's known as the Comstock Act, and his magazine was called Good Times. So, he published some pretty questionable materials, nude photographs, and partial nudes. So on the day the court heard this case, there was a long-standing view that both the state and federal obscenity laws were constitutional. And in Roth, the court begins to define obscene speech as unprotected. And the quote, I'm reading from the opinion, the quote says that, the brief says, the average person applying contemporary community standards finds that it appeals to the prurient interest, which means having a lustful or lewd thoughts or wishes. So again, the Supreme Court is more or less defining or deferring to the individual states what they're going to define as obscene. So interestingly enough, Roth goes to jail, but the law remains on his side, and as a result, in the 60s and 70s, as a result of several things, among them being the sexual revolution, the pornography industry explodes. And this is where you get the famous quote from Justice Potter Stewart, where he says, I'll know pornography, I'll know it when I see it. And really, the court does not come up with a strong sense or standard until Miller, which we're going to talk about in a second, what obscenity is. All right, so here we have Cohen V California. We talked a little bit about this in class. And Cohen v. California. So it's April 1968. It's the height of the Vietnam War. Paul Robert Cohen wore a jacket with the words F the draft, walking into a Los Angeles courthouse. He was just walking and paying a parking ticket, and he was arrested for disturbing the peace by offensive conduct. So he appeals in Cohen v. California, and the Supreme Court says that one man's vulgarity is another man's lyric. Now, this is different, we said, from burning a draft card. Okay, we said that burning a draft card, the Supreme Court said, was unconstitutional, was not protected speech. But in this case, it was. All right, now we have 1971. We have Miller v. California. And again, this is kind of the culmination of defining what obscenity is. So Marvin Miller, as pictured here, was prosecuted under the state's obscenities laws. And on appeal, the justices reaffirmed the Roth decision, saying that, in effect, that a local judge or jury should define obscenity by applying local community standards. Obscenity is not necessarily the same thing as pornography, and pornography may or may not be obscene. So the following year, I know the court overturned Georgia's conviction of a theater owner for showing a film called Carnal Knowledge. And the court has heard subsequent cases dealing with obscene speech, but the Miller test has been used. It's the three-prong test to determine what is obscenity. And the Miller test is speech is obscene if, one, the average person applying a contemporary community standards finds that it appeals to the prurient interests. Number two, it depicts or describes a patently offensive sexual conduct specifically defined by state law. And three, if it lacks serious literary, artistic, and political or scientific value. So that's the three-prong approach that the Supreme Court uses to define obscenity. And finally, we have symbolic speech. Okay, and this is probably, a big one. There have been more constitutional amendments offered to the Constitution protecting flag burning, protecting the flag from being destroyed. Texas v. Johnson and U.S. v. Eichmann in 1989-1990. Now, before I continue, you should be taking a look at those years. Now, what do you notice about those years, and what do you notice about the political climate of those 2 years? So you know that during the 60s and early 70s, the court was a little bit more active. Some would call it a little bit more liberal in terms of expanding and protecting freedoms. So 1989, we're now under the Rehnquist court, so it's going to be a little bit more conservative. And that should give you, a little context as to what's happening. So in Texas v. Johnson, a man is arrested under state law for burning the American flag. And in both cases, the Supreme Court found that the state laws protecting the flag serve no purpose other than ensuing a government-imposed political idea, which is reverence for the flag. Nowhere is it found in the Constitution that burning the flag is prohibited. In fact, it is protected as symbolic speech. People may disagree with it, and there are strong feelings about this. And this is where we also get into maybe taking a knee during the national anthem. But this symbol has become a big fight for the First Amendment and freedom, symbolic freedom.